what I understand the case of the other side is that by a notice of removal, that 179C notice, about which Nabam Rabia had elaborated upon, it somehow froze the Deputy Speaker's power of disqualification. What is the other side's grievance? Secondly, they are aggrieved by a quia timid injunction of a bench of this court on 27th June, which they say is contrary to Kyoto's judgment, paragraph 110 in particular. And then, my lord, the decision of the governor to order a floor test on the 28th. These are the three aspects, the factual aspects, either by themselves or in conjunction with each other, which they seem to be agreed by, which they say somehow curtailed the jurisdiction, diluted it or restrained it of the Deputy Speaker's power of disqualification. But that's how I understand the case, and I'll only proceed on that basis. And therefore, incidentally, Lordships seems to have a feeling that there is something wrong about Nabam Rabia's case regarding the time period in particular, whether it should be from the notice issued under 179C or whether 181. The consideration of the resolution is the part from which the stay of hands by the Speaker should take place. That's the short conspectus of this case, and I'll address it very briefly. Now, the entire factual conspectus is between a 9-day period of 21st June and 30th June 2020. Everything happened in that time. About what happened that is so alarmed the other side or so prejudiced them. On 21st June, I issued that notice under 179C. That notice asking him to stay his hands because he had lost his majority according to me.
Mr. Jethmalani, yesterday, everybody has gone through the chronological leadership events from 21st.
Yes.
You concentrate on, correct? Whether it should be equal to the larger.
Yes, no, sir.
That's the only thing which is.
But this factual conspectus.
Factual we have already considered, reconsidered.
Yes, the factual conspectus has some bearing on that question. That's why I'm telling your lordship. I'm not going to go in any great detail. I'm just going to say that the notice which they are aggrieved by, in fact, was rejected on the 22nd itself. The notice played no part in causing any prejudice because I sent it on the 21st. They received it on the 21st or 22nd, as they said. And on the 24th, they communicated to me that this notice is without any jurisdiction. We have to verify. I'll just show you a reply. Only that one document, your lordship may kindly see. What is their reply? Because much has been said about this 179C notice. And please see what their reply is. It's a very short email which I want your lordships to read. May I quickly read it? As per the Honourable Speaker's direction for further process of the notice, following replies to be complied with, Speaker's order is reproduced below. This officer received a communication dated 22nd June at 11:30 a.m. addressed on the letterhead of Shiv Sena, legislative party, purported to be signed by 34 MLAs seeking my removal under Article 179C of the Constitution. The communication purported to be signed by 34 MLAs of the Shiv Sena legislature party was received from an email ID dated so-and-so, ID so-and-so, which is not a registered email ID of any of the 34 MLAs. Please note that all the 34 MLAs have signed it. Their signature is available in the Legislative Assembly. But this is the ground on which my notice was disposed of. Who has purportedly signed the same has also been hand-delivered by a person who is not a member of the Legislative Assembly. In view of the gravity of the subject matter of the said communication, it is imperative that the genuineness of the communication be verified and ascertained before taking the same on record. Therefore, unless and until the persons who have authorizedly signed the aforesaid communication satisfy the undersigned about the authenticity of any such notice, such communication is not liable to be taken on record or acted upon. And that's the sum and substance of what he said. Now, after this, I heard nothing more about this notice. What verification he had done. So the case which is based squarely on this notice is completely misconceived because nothing happened. This notice disappeared. They didn't verify it, they didn't tell me what happened. Now, what was the next step? Far from dealing with the notice, he then sends me a disqualification petition, a deputy speaker. A disqualification petition is sent, as your Lordship knows, to the 16 of the 34 MLAs. That's the next step. And the notice has no part to play in this case whatsoever. That disqualification petition is received by me on the 25th, admittedly, and I'm talking about the short period of facts within which this took place. It's sent to me on the 25th with a direction to reply on the 27th. Now, my Lord, your Lordship may just note one more thing, that under the 8th paragraph of the 10th schedule, rules are to be framed. Rules have to be framed. They are called the disqualification rules. Rule 7 prescribes that from the receipt of a petition by the noticee, by the person who is to be disqualified, he has a right to reply within 7 days. This is Rule 7.3a. No, it's 7.3b. 7.3b. I'll just read it quickly. If the petition complies with the requirements of Rule 6, that is the disqualification petition, the Speaker shall cause copies of the petition and of annexures thereto to be forwarded to the member in relation to whom the petition has been made, and where such member belongs to any legislature party, and such petition has not been made by the leader thereof, also to such leader, and such member or leader shall within 7 days of the receipt of such copies or within such further period as the Speaker may for sufficient cause allow, forward his comments in writing thereon to the Speaker. I have a right, as per the rules framed by them, the Maharashtra Legislative Assembly, under paragraph 8, to reply within 7 days.
So the notice was not in accordance with Rule 7.3b according to.
That's the trigger, one of the triggers.
So then what is the next point then?
Next point is we move the Supreme, this Honorable Court.
Excellent.
And the bench, one of the grounds taken there, but it's contrary to Rule 7. Please give us extended time.
27th you move the Supreme Court.
We moved the Supreme Court on 27th. On 26th, matter came up on 27th. Now your Lordship will just see that order. Because they seem to be aggrieved by that. The second aspect of this case which they are aggrieved by is that so-called quia timet order of 27, which is not a quia timet order. It is only, there are only two aspects of that order. Order dated 27.
Our court postponed the date for submission of the reply to 12th of July.
To 12? And no, there's a very significant aspect also. I was in Guwahati at that time. Now, not that it has a great bearing on this case, but I was given the protection order. Please see the last paragraph of that order. I complained that I'm in Guwahati. Mr. Shinde, the now CCM, his son's office was burnt. And my Lord, I was receiving, the 34 MLAs were receiving threats. My Lord, very serious threats, which is part of an affidavit we circulated yesterday. And my Lord, we asked for protection. We were told that if we come to Bombay, our dead bodies will be sent to a moratorium. So, my Lord, this is what the court did. That's the only relevant part. Mr. Chitnis, in view of these allegations, Mr. Chitnis, learned counsel for the state of Maharashtra, states that adequate steps have already been taken and the state government shall further ensure that no harm is caused to the lives, liberties and properties of, my Lord, by that time it had swelled to 39 MLAs, of the 39 MLAs and their families. So, my Lord, those are the two aspects of the case. Now, how does that prejudice them? The state of Maharashtra voluntarily makes a statement. There is an explosive situation going on in the state of Maharashtra. These legislators and their family members were threatened.
The issue of whether or not to refer Nabam, what is the sequitur, so that you can formulate the point and tell us?
Yes. Now, my Lord, the thought to refer is that all these aspects which they claim to be aggrieved by. Well, as I said, there are three aspects. One is the notice. The second is the quia timet injunction, which is not a quia timet injunction at all. No prejudice was caused to them. And this order was passed on the 27th. Please note, my Lord, that on the 28th, the governor orders a floor test. What prejudice has been caused to the Speaker in the discharge, which, my Lord, of his power of disqualification? Where is the prejudice which my learned friends, my Lord, have my Lord, so profusely argued about? 28th, this floor test is called. Now, my Lord, the floor test, your Lordship, I will only cite one judgment. My Lord, the judgment in Shivraj Chauhan's case. So, my Lord, I'll just, the relevant paragraphs only. My Lord, this is at 1376 PDF, page 1376.
Volume 1.
Compilation. Volume 1.
Volume 1. Judgment compilation. But this is titled Short Circuiting the Speaker's Discretion. This is what they seem to be aggrieved by. I'll just read this now.
Just a moment, please.
A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the Speaker on the decision by the Governor to call for the trust vote.
Just one.
Yes, sorry.
We've yet to get it. Some.
I'm sorry.
Yes, please.
A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the Speaker on the decision by the Governor to call for the trust vote is that convening a trust vote at this stage will impinge on the discretion of the Speaker to determine whether the resignation should be accepted under the provisos of Section 193B, and at the second level to decide upon the consequence of the resignation in terms of the anti-defection provision of the 10th schedule. Short-circuiting is the phrase which was used by Dr. Singhvi. Implicit in the submission is the charge that holding a trust vote impinges upon the discretion of the Speaker on whether to accept the resignations and to decide whether these members have incurred the wrath of disqualification. While analyzing the submission articulated by Dr. Singhvi, the cobwebs need to be cleared. The Governor does not decide whether the resignations that were submitted by the members were genuine and voluntary. That is squarely a matter which lies within the domain of the Speaker. Similarly, but not I emphasize, whether a member of a House has discarded a disqualification under the 10th schedule is a matter where the Speaker is the designated authority. Conscious as this court has been on the fact that these matters, which lie within the domain of the Speaker in the recent past, a direction to members to appear before Speaker and the Speaker to take decision immediately was recalled by a 3-judge bench. Dr. Singhvi alluded to these orders. Now, number 80 is very important. It is strike law that neither the Governor nor, that for that matter, this court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the Speaker has taken a decision on whether or not to accept the resignations. And if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. The holding of a trust vote operates in a distinct field from the issue as to whether one or more individual members of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of the 10th schedule. The same thing here, the disqualification petition is under 21A of the 10th schedule.